We now turn to the fourth case on this morning's docket. That is case number 103918, State of Kansas v. Michael Randolph.
Good morning, Your Honors. May it please the Court, I am Sarah Ellen Johnson of the Capitol Appellate Defender Office, appearing today on behalf of Mr. Randolph. And, Your Honor, I would like to request 5 minutes for rebuttal, please.
5 minutes is granted.
First, we can take care of issue number 1 quite quickly. Obviously, after this brief was written, State v. Britt has come down, and I have no choice but to acknowledge that that controls on the alternative means issue. So we can dispose of issue number 1 and turn to the issue I'd like to discuss tonight, or this morning, is issue number 2, the question of the voluntariness of Mr. Randolph's statement. And the problem that we have in this case is that the state has the burden of establishing that a statement is voluntarily given. And in this case, the state, as a matter of policy, made the decision not to record the bulk of this interview. They met, or the interrogation, they met with Mr. Randolph for an hour and 15 minutes to an hour and a half, completely off the record, no recording, no nothing, and then get Mr. Randolph to the point of making the statement that they want to memorialize, and then they turn on an audio recording for 15 minutes.
That sounds like an issue of credibility.
Absolutely. But I think it's also, it goes beyond that. It goes to meeting your burden of production, meeting the burden that the state has in this case. We look at the other cases, recent cases where this court has found that a statement was involuntarily given. You think of Swanigan and Stone, the 2 cases cited in our briefs. This court was able to get to the point of establishing that those statements were coerced or were brought about by improper statements by the police or by them pressuring the defendant and saying, we have this evidence. And this court was able to watch the entire progression of that interview to see how we got to the final 15 minutes where the defendant gives up what the police interrogator is bound and determined to get out of him. We don't have that in this case. We have a cop acknowledging, yes, I think I said maybe we had some DNA evidence or we were going to have it, and it turns out, oh, no, we didn't, which is what happened again in Stone and Swanigan, claims that there's physical evidence that really doesn't exist. And we know that we have a defendant who doesn't even understand what the word coercion is. We have that from the police officer. But that's all we really have because we don't have the luxury of watching the rest of this statement. One thing.
Did the defendant testify at the suppression hearing?
No, and what I was just about to mention is that the judge made a comment about that, which I find troubling because, of course, the defendant has no burden at all in this matter. And to suggest that the fact that the defendant didn't testify is somehow evidence supporting the state's version of events, I think maybe puts more of a burden on the defendant to produce evidence and to testify than is proper to do. The reality is that we need to acknowledge is that even if the defendant had testified, the police officer goes into court with an aura of credibility that no defendant is ever going to have.
No, but you were talking about the production of evidence, and here, to me, where the defendant's testimony would be critical is what was he claiming was coercive. You're asking the state to disprove all possible allegations. If there's some allegation that I was tricked or whatever, doesn't the defendant at least have to raise what the defendant believes was improper?
Well, and that was done through the detective's testimony and through argument. There were 2 main points that were made. First, the claims that we have DNA evidence, which were used to lead directly to Mr. Randolph saying something about inserting fingers. and licking of the fingers and then inserting them because there was some claim that there might have been saliva. We also know that there was discussion, and we know this through the detective's testimony, about maybe Mr. Randolph blacked out. And in our brief, we've cited from a law review article that talks about this blackout language being a very common thing that occurs in false confession cases, and it being a particularly difficult box for a defendant to get out of. It's a really untenable position because either your response is, no, I didn't black out. Oh, so you remember everything. Or, oh, yeah, I could have blacked out. And so maybe that's where you don't remember what happened, but here's what's really happening. And so we have those 2 points from the detective's testimony, and those were the points that defense counsel argued below, and where the coercive nature comes in, that you're led to believe that there's physical evidence, led to think that, oh, I must have blacked out, and it's easy to progress from that point to just, I guess I must have done something that is not a free and voluntary confession. It's a coercive nature. It turns out, the DNA evidence wasn't true. And of course, we can't watch how this happened. So this court is at disadvantage that you were not at in Flanagan and in Stone, where you can't see how easy perhaps it can be to lead somebody to make this false confession in the last 15 minutes based on this very skilled interrogator leading you there. But
it seems to me that your client's testimony at trial weakens your argument. Certainly we know that the detective said, yes, I'll agree that the implication of DNA evidence was on the table. But when your client testifies, he's pretty specific. He says the detective told me they found 2 spots of DNA or something like that, which is true. They did. And then he goes on later and he says, the detective said, we have your DNA. And the defendant says, they did. They just took my DNA sample. He knew that it was at the beginning of the interview that they took his DNA sample, and he makes that pretty clear, that he understands they have his DNA, they have the victim's DNA, and they have 2 spots at least of DNA. But he seems to pretty much understand that there's the possibility of linking that in the future, but and so I'm not sure how that's coercive, because those are all facts.
Absolutely. The implication at the interrogation was stronger than that, I think. And that's certainly the argument that defense counsel at the suppression hearing was making, that you're not just saying we might be able to establish that this DNA evidence that or these spots that we found will turn out to be your DNA, but a much more conclusive, we've got your DNA. We've got this DNA, we know it's yours, and that all turns out not to be true. And of course, in the immediate rush of facing these allegations that you've now been stewing about for several days, that you don't know where they've come from, and now you're being told that we have DNA, we're going to prove it's yours, that's where the coercive nature comes in. And, perhaps it's not persuasive to this court. Again, I would point out that perhaps it would be if we had the video to actually, or audio at least, to hear what had actually transpired and how those statements were made to Mr. Randolph, to explain how he could get to the point of being coerced by that. And of course, again, remember that Mr. Randolph didn't even understand what the word coercion meant, which to me might suggest that he's even more susceptible to being talked around without even realizing that that's what's happening to him. So that's the best argument that I can make on that.
Yeah, I assume you'd probably cite us to a case, but do you have any case that would reference interrogation practices about when there is the ability to record or document the interview, and because of procedure they choose not to, that would lead us in a direction where that's so abusive or can lead to coercion that we need to take caution?
I don't have any cases. The best I can cite to you, and it's in our brief, is recommendations from groups like the Innocence Project and people who have exhaustively studied the wrongful convictions. Recording the entire interview truly is the best practice.
Well, especially when you have the means to do it. Not only the means to do it, you do it, but you just choose to kind of portions in which to utilize the documentation and other portions not to.
Right, maybe
seems suspect.
I certainly agree, but of course I'm a defense attorney, so it's my job to find that suspect. But the idea that you work around to getting exactly the statement that you want before you turn on the recorder, what are you covering up? What do you not want people to see?
Certainly leads to that question.
It does raise that question, and of course the defendant has no opportunity on his own to record that. It is entirely within the power of the state to choose whether to preserve that evidence or not. And I think that is problematic given what we know from the innocence cases. And so that's why we're troubled.
What the defendant has the right to do is say, I don't want to talk to you immediately. I'm not talking to you. I mean,
would that they all did, Your Honor.
Well.
Absolutely. But so that is our argument. I see that I'm out of time. I would submit the additional issues in the brief and ask this court to reverse Mr. Randolph's conviction. Thank you.
Do we have any questions of counsel before she sits down? All right, thank you, counsel.
May it please the Court, Christopher Schneider, Assistant Wyandotte County District Attorney, appearing on behalf of the appellee.
Mr. Schneider, could you start where I just left off? What is the justification for the interviewing of one part of an interview but not recording the other part? You said the detective said that's just how we do it. Well, why do you do it that way?
Well, I think a couple or three reasons. The first may well be because that's the way they've always done it, and that's the way they've been trained, and that's how they proceed. The second is that though they have some facilities for videotaping interviews,
which they obviously do because they did here,
right? It's my understanding there are a couple of rooms that they can do that in. It's absolutely impossible to do that with every interview they do because of limitations. They only have a couple of rooms to do that. And then you get into a matter of what type of resources do you have available? Can you equip an unlimited number of rooms to do that kind of
well, we didn't have that problem here because this room was equipped.
Right.
Okay.
But you have other interviews going on at the same time. It's not just one interview that's going on with one suspect on any given day. Whether we like it or not, we have a sufficient amount of crime in our community that we have lots of investigations going on at once, and there's not just you can't just dedicate resources to one particular investigation. You have multiple investigations that the department as a whole is having to deal with at any given time.
So there is only one or two cameras available to law enforcement, and they're kind of kept in a central location, and when each interview comes to the critical point where they want to have it recorded, they go check out the recorder. It's like a library, and they record that part of the confession. Then when it's done, it goes back to the central desk, and then it's available for everybody else. It doesn't seem like that's what you have because you said there are rooms equipped.
Right, the room's equipped because they're not where you actually physically take a camera and do it. It's a room that has the cameras, such as up here, set up where...
And my point is, what additional resource is required if you're in the room that has the recording capability in the first place?
If you're there the whole time, then it's a matter of just doing it, just activating it, or having it.
But here it was...
But...
what I call an initial interview done in room one, and then when you got to the point you wanted, you went to the recording room.
That would be my understanding of how it works.
So there was a physical change of environment in this case. The detective and Mr. Randolph were in a one interrogation room, and then when he's ready to make the statement, you move him to a different room? Is that what happens?
I can't tell you that is exactly what happened here because I I don't know, and I would be, I can't tell you that for sure. It's my understanding that's how the procedure works.
But don't you see how all this lends itself that there's something to hide?
Oh, I understand.
You understand that?
I understand, and I agree. If there were unlimited resources, that would be the way to do it.
That's not what we're talking about,
as-
though. I want to focus on the question because we're talking around it. If law enforcement has the capacity to flip the switch and record at the beginning of the interview, what's the argument for not doing it? Let's not worry about whether we can do it in all cases. Let's not worry about a perfect world. Let's just assume we're in a room where we can flip a switch. Is there any reason not to flip the switch and record the whole interview to protect against this kind of argument?
And again, as a prosecutor, I would say that's the best way to do it. I wish they would do that in every case. I think the detectives will tell you that they're trying to get their bearings when they're initially coming into contact with an individual, and so they're sitting down trying to figure out where are we here, what, maybe even do I have the right person, but is what I'm doing, am I on the right track before they go and make a formal statement.
What's the right track?
Oh, on the right track. Am I looking at the right person? Am I asking the right questions? Am I looking at the right person? Maybe this isn't even the right person.
Well, this is a major crime. We're dealing with a life sentence here.
Right.
And again, as Justice Biles pointed out, just to prevent what we're talking about here, what prevents starting that recording, which is important, right at the outset? I haven't, other than resources, which doesn't get me very far, or routine.
Well, and as I indicated, I as a prosecutor, I would prefer that the whole thing be there because it gives me, if I'm sitting and looking at a case to evaluate, to file or to try, it gives me a whole lot better perspective on what's going on too. But for resource reasons, for training reasons, they didn't do it. But just because they didn't do it doesn't mean that the statement's not admissible. Doesn't mean that the district court erred in admitting the statement.
We don't, excuse me, we don't have any evidence here that this was for resource reasons, that they didn't conduct the entire interview by videotape, do we?
I don't believe so, no, Judge.
Just your statement today. Is there anything in the record indicating they moved him from one room to another, one room that wasn't equipped and one room that was? Do we even know that here?
I'm not sure that we do, Judge.
We just know that one portion was recorded and one portion wasn't. So everything you're saying here is what you know of to be the practice at some point, or in
Right.
some cases, but we don't have any idea if that's why they did it here, because of a lack of available space, camera that where it's equipped already. He may
yes,
have
you're
been
correct.
he may have
You're
been in the room that was equipped, the interview room equipped with the video capability the whole time. Isn't that right?
He may have, and I don't know whether he was or not.
Okay.
I don't know.
In the old days, before we had a recording capability, if there was a confession, it might be reduced to writing and that introduced into trial as evidence, or the interrogating officers just would come to trial and say, this is what the defendant told me, and these are the circumstances. Is that
Right. I've been around long enough. Yeah, well, I remember those days. Yes.
recorded on papyrus, was it?
Well, and that's what my 16-year-old would say. Yes. Actually, he would tell me it was chiseled in stone.
Very good.
But the record does reflect that in this case, the get the bearings period was 75 minutes, an hour and 15 minutes to
believe that's
get
correct.
their bearings and see where they are.
I think that's correct. And at least right in that vicinity. But in this case, Judge Johnson took a look at, and he used the analysis that this court has said needs to be used in set out in Jackson and in Stone, and he looked at each of those individual elements: the mental condition of the accused, the manner and duration of the interrogation, the ability of the accused to communicate on request with the outside world, his age, intellectual background, the fairness of the officers in conducting the interrogation.
And two of those critical ones, manner and fairness, we just don't know about because the means by which that can be ascertained was not preserved.
Well, we know from the testimony of Detective Cantwell.
Right.
And the court the trial court then had to judge Detective Cantwell's credibility, or make a determination of Detective Cantwell's credibility. But based on the evidence that the court had before it, it did not err in making its decision. And again, the court looked at all of those, and into the totality of the circumstances, which ultimately is the standard that gets used. The district court, looking at all of the circumstances, did not err in admitting the confession. I would indicate that I think this matter does need to be remanded to the district court to clean up the sentencing. This is one of those lifetime parole versus lifetime post-release issues where the sentencing court was not real clear about, and so I think it needs to go back to have that sentencing part cleaned up and corrected. And it should.
Does the sentencing court have jurisdiction to do a nunc-pro-tunc on those journal entries that have checked this box while the appeal is pending? In other words, I
would argue that I would make an argument that they could, and I would suggest that if you tell the sentencing court it can do that, then that's the way we should proceed. The remainder of the issues, as did counsel for the appellant, I would submit to the court on the briefs unless there are any questions.
Any further questions of counsel? Thank you, counsel.
Thank you, Mr. Chief Justice.
Just very briefly to clarify some of the questions about the record that came up during my opponent's presentation. From Detective Cantwell's testimony, there's no reference to switching rooms, and from the way he's talking about, we could have recorded the entire interview. It reads to me like they did not switch rooms, but there's definitely no statement that they did. And as for an explanation for why they don't record the whole thing, he simply says it's our policy. We don't want 2 hours of audio tape, which doesn't make a whole lot of sense in the era of DVDs, because it would be the same amount of DVD for 15 minutes as for an hour and a half. And then he says it would be repetitive to have the entire interview. So those are the explanations. And if there are no further questions, I would again ask.
Do you see an impediment to a nunc-pro-tunc while the appeal is pending?
Honestly, Your Honor, I heard that question come up yesterday during argument, and I've thought about it, and I can't think of any. It always makes me leery to turn down the opportunity to be remanded, but on a practical level, I can't think of any.
Do you have a concern, counsel, if we were to make a ruling that if you have the recording equipment and you're going to record any part of the interview, it needs to record the whole interview? Do you have any concern that if we issue an order like that or put that in our opinion that law enforcement units around the state say fine and we just will not record any part of it? Where does that leave us?
I certainly would hate to see that be the result. That seems an unfortunate opportunity, but I'm not sure that leaves us in any worse position than we are with the counties now that choose which parts to record and which parts not to record. If I had my way, every interview of every suspect ever would be recorded in its entirety. But I certainly wouldn't want to see this court, not take a step to improve the integrity of the interview or the suspect interrogation process out of concern that some sheriff's department somewhere might have a petty response.
Very good. Any further questions of counsel? Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement. That concludes this morning's docket. Kate, the court is in recess until 9 o'clock tomorrow morning.